when we return from lunch, I will address Mr. Ray Greenlaw's defense counsel regarding their position on an opening statement. I could have done that before lunch, I just thought we'd do it after lunch.
I have to schedule witnesses, so I need to know if they're going to be.
I'd indicated I was going to,
Still standing with them? Okay.
How many witnesses will you have available at that 1:45 time frame?
I've asked Eric and Nicole Robinson to be here at 1, and Diane Cowley, I think, to be here at 2:30 or 3, and Mary Fitzgerald to be here around 3, and Kirk Madison to be here before 3:30. And I think that may fill the afternoon, honestly.
Are any of those witnesses, does the issue of the reputation come up through any of those witnesses?
Yes,
Okay, which ones?
all
Okay, so we do need to address that. Everyone may be seated, sorry. I didn't know that we were going to be here for a while. Now that we are having a joint presentation of the witnesses, does that affect in any way what we talked about on Monday regarding Mr. Will was asking that when he concluded with his testimony, we address the issue before they left to see whether or not they needed to come back and testify in that regard. Now that they're being presented as joint witnesses, that changes the scenario slightly, but how do you want to deal with it at this point?
Can you give me 1 minute so that I can confer? We didn't discuss this issue, but I have what my thoughts are.
Yes, sir.
Judge, I can represent for both attorneys representing both clients that we will not be using reputation evidence in this case.
All right. That clears up that issue.
One other thing that came up during opening, I just want to put everybody on notice with respect to Steve's opening. He made mention of a video recreation of the shooting power of the shotgun. I'm going to be filing a motion for me. I received the video last night, took a quick look at it on the process of drafting. I think it's subject to some debate, and so I don't mind what was said, and I don't care, and I don't think they focused on it at all. But I just want to let everybody know that I will be filing a motion as soon as I can.
And I understand that, and to the extent possible, we're still having the firearm expert next Friday, or was that schedule changed?
Well, based on kind of where we were yesterday, I'm going to see if I can't get him in here, get a flight. I had to cancel one flight. Get another flight in on Friday, that's going to be Stacy this afternoon. See if we can get him in maybe on Thursday, just as an abundance of caution in case we get that.
I understand the schedule and the burden that you have of being by yourself. I do. Obviously, the motion needs to be provided to counsel and to the court with enough time for us to research it before it's presented and argued.
I would like to have it done tomorrow, and once I do, I can email it to everybody.
Okay. And we will make sure council's received it, had an opportunity to research it before we actually have a hearing on it. We can just figure out which break, which morning, which evening we can address that, but it needs to be before, obviously, the firearm expert testifies.
And I'd also like, while we're on the subject, I'd like to take the deposition, or at least speak to their witness prior to my firearm expert.
Right. I'm glad you reminded me of that. So we just need to know his schedule and then build that additional time in before he testifies.
I'm going to get him here, so my guess would be that maybe
All of you want. I can do it by submission. Yeah, I don't care.
Just update us on the schedule, and we'll address the schedule when we'll address the motion in limine after we've seen it and researched it.
Yeah.
Anything else? I do want to take this opportunity because I don't think anybody from the audience left, and I still have both defendants here. Something I failed to do before we started, but it wasn't a problem. I just want to address courtroom decorum with everyone who is present. First of all, I'll start with the audience. I know that the state's victims advocate has addressed these issues with the families. I recognize that, and I know you've heard it. But I need to put something on the record so that it's clear that the judge is instructing you of the appropriate courtroom decorum. This applies to anybody in the courtroom. The family has had the benefit of having some prior counsel on that issue through the victim's advocate. The trial has to be conducted in a manner that allows the jury to focus on the witnesses and the evidence, and not to be distracted by anything. And that includes people in the audience making certain gestures, facial expression, signs of emotion, whether that be anger, crying, whatever. This is an emotional case. I do understand that. If you are affected by that emotion, you need to remove yourself from the courtroom so that it's not seen by the jury. You are not to express any pleasure or displeasure with any of the witnesses' testimony. To do so could distract or potentially sway the jury. It's my responsibility, and you'll see me scan the audience at several times. I also have other eyes in the courtroom that will alert me if they see a problem for me to then focus on it. I can remove you from the courtroom if you do not follow that instruction. I don't want to do that, but you need to understand the reason why that rule is in place and comply with it. I saw no violations this morning. That's not the reason I'm telling you. I'm telling you because now we're going to start with witnesses' testimony this afternoon, and so it can start to get a little bit more heated or more emotional. So now you've been advised, it's part of the record, and if I have to, I will enforce that by removing you from the courtroom if necessary. Same goes for the defendant. Again, I want to specifically address to both of you. You have never been a problem in this courtroom, and you've been coming for, 3.5 years. So this is not based on historical perspective at all. You are not a problem. You have never been a problem. And even to that effect, we have been able to do away with some certain constraints, restraints, and that we didn't feel were necessary in this case because of the way that you have conducted yourself in this court. However, I need to put on the record that you are subject to courtroom decorum. You have every opportunity to speak with your counsel about anything that you have heard or seen, but you are not to express any facial expression or emotional reaction to any of the witnesses' testimony. You got to put your poker face on while you're here in the courtroom. At breaks, you can go do what you want, but the jury has to be completely devoid of any potential distraction from you because of your reaction to the witness's testimony. Again, I have no historical reason to think you wouldn't comply with that, and this morning during opening statements, you didn't have any problem with that. But I have to put on the record that you've been instructed, because if you do violate that, I would probably have to remove the jury for a minute and instruct you again in a more stern manner. I could potentially look at some kind of restraints to prevent you from reacting. And if you continue to disregard the court's order in that manner, I could actually remove you from the courtroom. Even though this is your trial and you have a right to be present, you can violate that right by acting in that way. So I just want to make sure that you all understand that. I'm sure your counsel has advised you of that, but now it's clear and it is on the record. Right? Anything else we need to discuss before we recess for lunch? All right, I asked the jury to be back at 1:45. We'll get them back there, put their stuff down, take a few minutes, ask for Mr. Ballerino's position on whether or not they're going to make the opening statement, so that's clear and part of the record, and then hopefully your witnesses will be here for purposes. I do like to swear them in and instruct them on the rule of sequestration in front of the jury. I think that just enforces in the jury's mind they've got to stay away from everyone. So hopefully whatever witnesses are available, we can address that and then start the state's case.
Yes, ma'am.
All right, we're in recess till 1:45.